Do complex legal issues hold you back? Let's get energized and bring clarity to your top legal questions. This is Law Talk with the Flock by Goosmann Law Firm.
Hello, I'm your host, Jeana Goosmann, a CEO, lawyer, author, and woman business owner, here to help navigate you through the law, your business, and life as a leader. Today, we're going to continue with our CEO series on CEO mistakes that I see that CEOs are making. We will be discussing our issues around antitrust. Some of the issues I see around antitrust revolve just simply CEOs are unaware of antitrust issues at all. And a lot of times they don't even know that they should be concerned when there are issues in play. So we're going to outline a few of the things to be thinking about in order to help keep the CEOs out of the orange jumpsuit and out of big cases in court. Because if there are antitrust issues in play in your business, that is a serious, grave risk. And you want to make sure that you're mindful of them and to watch out for them. And if you don't know what you don't know, it's always great to talk to a lawyer who is in the know in order to be able to figure out what you should be thinking about when it comes to monopoly behavior and monopsony behavior. I want to first define that for you. So everybody usually thinks of a monopoly where you control the market on the customer side. A monopsony is when you control the market on the buy side or the supplier side. There are some other things to be concerned about and to raise your flag. So the administration is being really aggressive in America right now under the Biden administration when it comes to antitrust issues or big business or businesses controlling the market, especially in the inflationary environment that we're in when consumers are upset because we're paying so much money. The whole theory is if we don't have monopolies, there will be competition in the marketplace, and that will benefit the consumer. Some things to keep in mind. If you have sales over $92 million, that is an area, or if there's a company valuation over $92 million, that is an area to keep in mind that you might be triggering some antitrust issues if you're going to sell your company and you're going to be paying or be receiving more than $92 million for that transaction. That is something that you'll want to have your lawyer make sure they review. Do you need to have that sale approved in the marketplace before you can complete that transaction? Also, if you have more than 80% of the market share in your particular market, that is something to be mindful of because you can have a higher level of scrutiny applied to you under the law when you have more than 80% of the market. Now, how do you define the market? That's a tricky situation. Both geographically and product line wise, it takes a lot of analysis in order to define what is that market. And that's a further discussion and probably some analysis you should review with your attorney. Now, the big one is sharing prices with a competitor. A lot of times there are friendly competitors, people that are in adjacent markets, or you meet each other at trade shows every year and you want to talk about the business. Anytime that you price share with your competitor, that is a big red flag, and you want to make sure that you're not doing that. I've seen it come up too in bidding situations where people might share their bid numbers. Don't want to be doing that. If you have a certain type of product that you want to kind of set the floor for or something like that, you don't want to do that. Email traffic going back about the pricing between you and your competitors, or creating a price list or a price sheet, all things that you want to avoid doing. Also, watch out for trade associations. Those can be groups in which you do develop those relationships, and it might be tempting to talk about pricing among those trade associations. Trade associations should have rules within them to help protect their members from violating the Sherman Act or the antitrust laws in the jurisdiction. A little note, especially because we're based here in the Midwest and we have a lot of co-ops. In general, co-ops are exempt through a rule called the Capper-Volstead Act. And under Capper-Volstead, you can set prices in a co-op, but the key is you have to be farmers in the co-op. And so they get this special protection. If you're wondering, well, how in the heck do the co-ops get to set prices? That's how. But they then need to make sure that they are staying compliant under Capper-Volstead. The DOJ is a sleeper. That's the Department of Justice, the federal government, they can be building a case, investigating a case, and you have no idea that they are building a case, and that could be going on for years. They might be investigating a certain area. They could take 5 years if they want to in order to investigate and build up their evidence. And all of a sudden, one day, boom, you get a notice. Maybe it's a subpoena or grand jury investigation or something like that. And now you need to contact your lawyer immediately because you were under the gun and the microscope of the federal government when it comes to potential antitrust violations. Another way that the government finds out that some of this stuff is occurring could be from former employees. If you have disgruntled employees or whistleblowers, there are also whistleblowers that are able to take information to the government and let them know that this is going on in a particular industry. So lots of things to be mindful of. I just really want to make sure that CEOs are aware of these issues. And you don't have to be a mega corporation. This doesn't just apply to the Googles and the Apples of the world today, but it can apply to Midwest companies that are doing business, especially in the ag industry. I think that food is something that is really under the scrutiny right now in agriculture, and there have been a lot of antitrust cases in the ag sector. So I think it's important that this be talked about and that people be mindful of this and consult their attorney to make sure that they are taking appropriate steps to mitigate risk and make sure that you know the law and that you are in compliance. Thank you so much. Have a great day, everyone. Go make it worth it. Goodbye.
Thanks for joining us for Law Talk with the Flock by Goosmann Law Firm. We hope you feel energized and ready to soar past your goals. Become a Flock fan and subscribe to our podcast for weekly episodes. Learn more at goosmannlaw.com.